I call this meeting to order. So welcome to meeting number 109 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference referred to the committee on Wednesday, May 29th, 2024, and the motion adopted by the committee on Monday, May 27, 2024, the committee commences its study of Bill C-70, an act respecting countering foreign interference. Before we begin, I would like to ask all members and other in-person participants to consult the cards on the table for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, including the interpreters. Only use a black approved earpiece. The former gray earpieces must no longer be used. Keep your earpiece away from all microphones at all times. When you're not using your earpiece, place it face down on a sticker placed on the table for this purpose. Thank you all for your participation. Today's meeting is taking place in a hybrid format. I would like to make a few comments for the benefit of members and witnesses. Please wait until I recognize you by name before speaking. A reminder that all comments should be addressed through the chair. And so I would now like to welcome our witnesses today. With the Department of Public Safety and Emergency Preparedness, we have Sébastien Aubertin-Giguère, and I apologize for the name, I can't necessarily pronounce it correctly, Associate Assistant Deputy Minister, National and Cybersecurity, and Richard Bilodeau, Director General. With the Canadian Security Intelligence Service, we have Sarah Estabrooks, Director General, Policy and Foreign Relations, Renee Ouellette, Director General, Academic Outreach and Stakeholder Engagement. And with the Department of Justice, we have Heather Watts, Deputy Assistant Deputy Minister, Mark Scrivens, Senior Counsel, and Corinne Bolduc, Counsel. I thank you all for being here at such short notice. I now invite Public Safety Canada to make an opening statement of up to 5 minutes. Please go ahead.
Thank you, Mr. Chair. Comme vous le savez, le Canada et les alliés.
As you may know, Canada and its allies face numerous geopolitical challenges that threaten to destabilize democratic nations and the global economy every day. The strength of Canada's national security and public safety is being tested. Notably, threats from China, Russia, and Iran continue to threaten our national security and social cohesion. And what has captured the attention of many Canadians, rightly so, is the insidious threat of foreign interference. Interference remains a critical threat to our national security.
Malign activities undertaken by foreign states or those acting on their behalf to advance their own strategic goals to the detriment of Canada's national interest and that of our allies. Foreign interference targets the integrity of our political system, democratic institutions, social cohesion, academic freedom, economy, and long-term prosperity. The threat of foreign interference is not new, but it has increased in recent years as the world becomes more competitive, interconnected, and digital. The Government of Canada is best served when engaging with those directly affected by national security threats on potential solutions. For this reason, we consulted with a diverse group of Canadian stakeholders and partners on potential updates to modernize our counter-foreign interference toolkit in a way that balances various important considerations such as privacy and charter-protected rights and freedoms. On May 6, 2024, the Government of Canada introduced an act respecting countering foreign interference, also known as Bill C-70, that reflects the valuable input received through the consultations from stakeholders across Canada. The changing global threat landscape and the way in which foreign interference materializes necessitated a modernization of Canada's toolkit for countering foreign interference in all its forms. And while others will speak to the various amendments to the CSIS Act, to the Security of Information Act, and the Criminal Code, aimed at better detecting and disrupting this strategic threat, I would like to highlight Part 4 of the bill for you, the Foreign Influence, Transparency, and Accountability Act. As mentioned, foreign interference takes many forms, but malign foreign influence, a subset of FI, remains particularly difficult to detect and to counter. Some governments and their proxies may leverage individuals or entities to undertake non-transparent influence activities that are intended to shape Canadian policy outcomes or public opinion, deliberately obfuscating the foreign ties. And the intent of the FITA, the Foreign Influence Transparency and Accountability Act, is to promote openness and transparency around ties to foreign states. And in doing so, to deter and introduce robust consequences for those who seek to exert influence in non-transparent ways. Foreign influence transparency registries are increasingly considered an international best practice. We've engaged with our closest allies and like-minded partners to learn from their experiences in designing our own registry. There are three criteria that, when taken together, would trigger the requirement to register under the FITA. First, an individual or an entity that enters into an arrangement with a foreign principal, where the individual or the entity acts at the direction or in association with a foreign principal to engage in foreign influence activities. Second, when that person or the entity undertakes any of the following foreign influence activities: communication with a public office holder, communication or dissemination of information to the public, disbursement of money or things of value. And thirdly, the activity is undertaken in relation to a political or government process. So I want to be clear that it's not the foreign principals that would be required to register. Instead, those individuals or entities acting at the direction of or in association with those foreign principals would have the registration obligation. And there's no registration obligation imposed on anyone who is the subject of this influence activity either. So before passing to my colleague, I would just note that the registry was designed to be country agnostic, and it's a tool to protect, not persecute, communities from diverse ethnic and cultural backgrounds in Canada. So with that, I look forward to your questions. Thank you.
Thank you. We go now to, we invite CSIS to make an opening statement of up to 5 minutes as well. Go ahead, please.
Good morning, and thank you for the opportunity to be here in support of this important study. Since its creation 40 years ago, CSIS has had to adapt to major changes in the threat landscape to protect Canada and Canadians. From our inception at the height of the Cold War to today's era of global cyber-enabled threats, CSIS has had to continuously evolve its operations. Although foreign interference is not new, the complexity of the modern threat, fueled by technology, highlights the need for appropriate tools and authorities. Les lacunes dans les pouvoirs du HCR.
The problems with the law continue to arrive with the changing technology and the capacity to detect foreign interference, to make inquiries, and to intervene rapidly to protect the interests of Canada. The draft bill proposes some modifications that are very precise to improve operational measures that we can use to fight against foreign interference and meet these three objectives.
Interference extend well beyond the federal government. They include Canada's diverse communities, democratic processes at all levels of government, Canada's rich research system, our private sector, which drives the innovation economy, and the critical infrastructure upon which we rely. Amendments would authorize CSIS to equip national security partners outside the federal government. We have learned from Canadians, especially other levels of government, businesses, and diaspora and minority communities, that they would like more information about the threats they face so that they can build resilience against them. Deuxièmement, les modifications visent à faire en
Second, amendments seek to ensure CSIS can operate successfully in a digital world. CSIS has adapted to and embraced technology throughout its history, but the pace of technological development today is creating blind spots and vulnerabilities that foreign state adversaries and violent extremists are exploiting every single day. Finally, amendments that would enable CSIS to keep pace with emerging and rapidly evolving threats.
Address 5 areas of the CSIS Act. Amendments to current disclosure authorities would authorize information sharing outside the federal government to build resiliency to national security threats. New judicial authorizations are proposed, tailored to the requirements of modern digital investigations. To better leverage data in investigations, amendments are proposed to CSIS's existing data authorities. A tactical amendment to CSIS's foreign intelligence collection mandate to account for the borderless nature of data would better equip CSIS to collect on the intentions and capabilities of foreign states. And finally, review of the CSIS Act by Parliament every 5 years would ensure that CSIS can continue to adapt to emerging threats and changing technology. All of the proposed amendments were designed with strong safeguards in mind. We heard the importance of this from Canadians during our consultations. Par ailleurs, le SRS est toujours tenu de rendre des...
As well, CSIS remains accountable to the Minister of Public Safety, who can issue specific direction on any aspect of CSIS's activities. The Intelligence Commissioner will also continue to review and approve certain of our activities. In addition, all CSIS activities can be subject to review by the National Security and Intelligence Review Agency or the National Security and Intelligence Committee of Parliamentarians.
Review and oversight, including the vital role of the federal court, the legislation would ensure that all CSIS activities to protect Canada and Canadians comply with the Charter of Rights and Freedoms. With that, I welcome the opportunity to discuss any aspect of the proposed amendments to the CSIS Act. Thank you.
Thank you. We go now to Justice Canada. Please, remarks up to 5 minutes, please.
Good morning. Thank you very much, Chair. I'm here to speak to the Justice Canada proposals that you'll find in Bill C-70, in particular those that amend the Security of Information Act, the Criminal Code, and the Canada Evidence Act. The Security of Information Act, or the SOIA as I'll call it, is the primary legislation dealing with foreign interference. Part 2 of Bill C-70 creates 3 new offenses in the SOIA. The first new offense is a general foreign interference offense. This would make it an offense to do any surreptitious or deceptive act for a foreign entity knowing that it would cause harm to Canadian interests. The second offense is the commission of an indictable offense for a foreign entity. This offense would apply when someone commits an indictable offense for a foreign entity. It could be any indictable offense, for example, extortion or bribery. The third new proposed offense is an interference with democratic processes offense. The bill creates a new offense of committing a surreptitious or deceptive act at the direction of, in association with a foreign entity to influence a political process or educational governance in Canada. This offense would apply to all levels of government, territorial, provincial, Indigenous, municipal, and would apply to the nomination processes of political parties. This offense would apply at all times, including outside of the formal election period. Secondly, the bill also amends some of the existing offenses that we already have in the SOIA. Section 20 already deals with threats or violence in relation to a foreign entity. Bill C-70 makes it easier to prove this offense by removing the necessity for prosecutors to prove that the offense was committed for the purposes of aiding a foreign entity or was likely to harm Canada. This is a significant modification to Section 20 that would aid in the investigation and prosecution of persons involved in transnational repression, because the intimidation of critics of foreign regimes don't always engage the interests of the Canadian state in a direct way. There's also a proposed amendment to Section 22 of the SOIA, which deals with preparatory acts. The bill increases the maximum penalty for the commission of a preparatory act from 2 years to 5 years and expands the application of that offense to most of the offenses in the SOIA, including the new ones proposed in this bill. For all of the SOIA offenses, including the new ones, there will be a requirement to obtain Attorney General consent before commencing a prosecution. Finally, Bill C-70 also contains a proposed amendment to the definition of special operational information in the SOIA to address the inappropriate sharing of military technology and knowledge. Turning now to the Criminal Code. The Criminal Code currently contains an offense of sabotage that has not been revised since 1951. The amendments in Bill C-70 will modernize this offense. The bill creates a new sabotage offense focused on conduct directed at essential infrastructure and contains a list of what constitutes essential infrastructure for this purpose, including transportation, energy, health, and communications infrastructure, among other categories. The current sabotage offense already provides for exemptions from criminal liability for work stoppages related to labor action or safety concerns. The proposed new offense also recognizes, for greater certainty, the right to advocacy, protest, and dissent. Finally, the bill adds a new companion offense to criminalize making, possessing, selling, or distributing a device to commit the offense of sabotage. The maximum penalty for these 3 sabotage offenses is 10 years. As with the new offenses in the SOIA, the bill adds an additional safeguard by requiring Attorney General consent before a prosecution for the offense of sabotage can be commenced. Turning now to the amendments to the Canada Evidence Act and the Criminal Code in Bill C-70. Currently, the Canada Evidence Act provides a regime that protects sensitive information from disclosure in court proceedings, but generally does not allow the courts to consider that information when deciding the matter before them. Il existe cependant certains régimes autonomes.
However, there are some standalone regimes that allow for the protection and use of sensitive information in administrative proceedings. The judge can take the sensitive information into account when making their decision.
Judicial review, for example, in connection with charities registration and revocations, terrorist listing entities, the Passenger Protect Program, and some passport revocations and refusals. Le projet de loi abroge ces régimes autonomes.
The bill repeals these existing standalone regimes and establishes a uniform process, a secure administrative review procedure for federal administrative proceedings applicable to federal court or appeal or judicial reviews and appeals.
Information that's part of the record. Finally, with regard to criminal proceedings, the bill makes 2 specific changes involving interlocutory appeals and sealing orders to improve the efficiency and limit delays in the criminal process. Thank you for having us, and I'm happy to take any questions.
Thank you all for your remarks. We'll start our questioning with Mr. Cooper for 6 minutes, please.
Thank you very much, Mr. Chair. I will direct my questions to the public safety officials. How long will it take to implement the Foreign Influence Registry upon Bill C-70 receiving royal assent?
So thank you, Chair, for that question. It's something that is currently before Parliament, and we're going to see where it goes before Parliament. It is going to be a priority for us to set up the office based on the legislation if and when it is adopted to Parliament. We do recognize that there's significant interest in making sure that it is up and running before the next federal election. It is going to be a priority for us to set it up. There are numerous pieces of work that need to be done in terms of bringing in regulation to support implementation of the Act that will need to be done before we can actually bring it into force. It'll be up to the Governor and Council to determine when that coming into force is.
Well, thank you for that. Through you, Mr. Chair, there is regulation that needs to be set out, as well as setting up the commissioner who's going to oversee the registry. And so would it be fair to say it would take a number of months? Because my understanding, at least from the technical briefing, was that it may in fact take up to a year. Am I correct?
It could take up into a year. Not to get too much into the weeds in terms of bringing in regulations. There's a process for regulation, as the chair is aware. There's also a need in the legislation. The Commissioner for Transparency would be obligated to publish a registry to make known individuals who have registered. There is going to be a need to stand up the system so that people can register and that the Commissioner can then publish that registry online to make that information available. And so during the technical briefing, we did indicate that a year is what we're working towards and is the goal that we will attempt to meet.
Well, thank you very much for that. And there is clearly a lot of work to be done. And when I look at the calendar, it's May 30th, and there's only a few more weeks left before the House rises for the summer. And so looking at the next election, That's October of 2025. That's about a year away right now, having regard for the fact that we only have a few sitting weeks. And so this is just, this underscores a real concern that I have that this will not be in place in time for the next election. And it's as a result of a government that has dragged its feet, dragged kicking and screaming to finally introduce a foreign influence registry, despite calls for years by security experts, by diaspora communities, by conservatives. Indeed, it is, I would submit, not a coincidence that this legislation was introduced the day after the first sitting day after the damning report of Madam Justice Hogue, a damning report, an indictment of the government, an indictment of the Prime Minister. This is nothing more than an attempt by this government to use this bill for political cover in the face of conclusions that demonstrate that that we have a Prime Minister who turned a blind eye to foreign interference. And I have to say, the delay is unacceptable because consultations for a foreign influence registry ended 1 year ago. And therefore, had the government introduced legislation a year ago, we would have a foreign influence registry in place well ahead of the next election. But because these Liberals have delayed and failed to act, here we are with the very real possibility that we won't have a foreign influence registry in place. And if there is one in place, it will be right at the time that the election is called, which raises questions about its effectiveness during the campaign period. And given the timeline that we have, it is why conservatives believe that it is absolutely imperative that we move this legislation forward quickly. It's why my colleague, Mr. Chong, the member for Wellington Halton Hills, introduced a motion yesterday in the House of Commons to see that this bill would pass through all legislative stages in the House by June the 12th. But incredibly, yesterday in the House, the government's coalition partner, the NDP, blocked Mr. Chong's motion. And so here we have the coalition partner of the Liberals who've dragged their feet for years, who are now obstructing moving this bill through Parliament. And I can't help wonder why that is. It certainly demonstrates that Jagmeet Singh, once again, is an unserious leader, having regard for the fact that he doesn't see the need to move this along. And it raises questions about whether the NDP is doing the government's dirty work.
Thank you, Mr. Cooper. We're going now to Ms. Saeed. Gentlemen?
Thank you, Chair.
Gentlemen, settle down, please. Ms. Saeed, please, go ahead. 6 minutes.
Thank you, Chair. Thank you to all the witnesses for appearing before the committee on this important legislation. My first question is for the CSIS department. Bill C-70 proposes amendments to the CSIS Act that would, among many other things, expand its warrant capabilities. So I have some concerns about this expansion of authority, given concerns regularly raised by the courts about CSIS not abiding by its duty of candor in warrant applications. So could you please outline reforms you have taken around your duty of candor to the courts and building trust with minority communities who have in the past felt targeted by CSIS and are the very communities often targeted by the foreign interference we are trying to guard against in this legislation?
Thank you for the question. The service has had a significant amount of effort in place to address previous concerns about significant gaps in our duty of candor. It is a duty that we take very seriously. The federal court and review bodies have pointed to concerns, and we have taken significant measures, including training, the development of a professional affiant corps, embedding legal counsel in various operational activities in order to really understand and fully meet the duty of candor to the service. We recognize that this is a failing that's unacceptable and that creates gaps in trust for Canadians. I'm going to pass it to my colleague Renee to speak to the second part of your question, if that's okay. Thank you.
Thank you for the question, Chair. I think the first thing we want to point out is that since 2019, we've created a program that significantly expands how the service does outreach and engagement with communities across the country, recognizing that it's our responsibility and our duty to protect all Canadians. We have deployed significant resources, time, and effort in rebuilding trust where trust had been lost or fractured, in acknowledging and atoning for some of the mistakes that we've made in the past with communities. And we have made some significant progress, I think, in building that trust. It takes time, it takes patience, of course, it takes humility, and we have brought all of that to bear in our efforts to build these relationships. And we continue to have them in daily conversations, weekly meetings, face-to-face, over the phone, emails, everything, to make sure that we are available to communities when they need to talk to somebody about the service or about threats that they're feeling, because we do recognize that, especially in the context of foreign interference, that often the first victims of that activity are communities themselves, diaspora communities, marginalized communities, and it's really important to us to make sure that we are, again, protecting the interests of all Canadians, not just.
Thank you. This legislation also enhances the CSIS capability to collect and use data sets. So obviously the protection of personal information, data management, and abiding by privacy protections is going to be very important here. So could you please outline what steps are being taken to address privacy concerns and to ensure data is properly obtained and is reliable before it is used?
Thank you for the question. The data set authority in the CSIS Act is an extremely complex regime that thoroughly embeds privacy protection at every step. It requires ministerial accountability and oversight. The collection and retention and use of data is undertaken through strict controls, including, for example, designated officials are only able to handle data in the evaluation period. It must be segregated from other CSIS holdings. There are a number of different steps in the approval process. The retention of Canadian data must go to the federal court for approval. So the scheme itself is heavily embedded with the appropriate safeguards for the privacy rights of Canadians, recognizing that that is the essential need for data, is to understand dynamics in our threat environment while at the same time protecting the privacy of Canadians. The amendments that are proposed in the bill make some significant changes in terms of the process, but they do nothing to change the safeguards. In fact, in some ways, they enhance safeguards. For example, currently, the service, when it seeks to retain a data set that contains both foreign and Canadian data, it goes through two tracks. And we're proposing an amendment that would see all data in mixed circumstances like that be applied to at the Canadian standard, which would mean it goes to the federal court. So none of the safeguards in the existing regime will change. The role of the federal court and the Intelligence Commissioner remain, as well as ministerial approval for classes of Canadian data sets and designations. So it's a significant improvement in process to enable us to better make use of data, but no change with regard to the safeguards the scheme already has in place.
Thank you. My next question is for the Department of Public Safety. Could you outline the concerns you have heard from the diaspora communities in regards to foreign interference, and what steps are you taking to ensure they are not inadvertently victimized or stigmatized by the efforts to combat foreign interference?
Thank you. We've received significant feedback from different communities across Canada. I'm not going to go into the specifics, not for attribution, obviously, and has been summarized in the What We Heard report. But very clearly, clear concerns around foreign repression, transnational repression, and more protections needed for these communities. We've heard also that they may have some concerns around being stigmatized, and it's pretty clear that the way the legislation was designed was to be country agnostic and making sure that it offers the right protections but does not identify or stigmatize a community. We also heard that any effort to counter foreign interference needs to be accompanied by clear messages around anti-racism, and we've been working very closely with Heritage Canada to make sure that we align with with their efforts for countering racism in Canada.
Thank you. I have to cut you off there now. Thank you. On y va maintenant, Monsieur Villemur.
Now, Mr. Villemur, 6 minutes. Thank you very much, Chair. Thank you to the witnesses. I'm going to start with the public safety. I'd like to know, in building the register, of course, there have been registries in other countries. There are a number of models, but what I was interested in, and I thought it was in the bill, but I don't see it, it's having a double registrations. So the foreign group must register and see and the local, and so that we can identify who they are. Why not have a double registration in the registry? Thank you very much for your question. The registry has been proposed to emphasize the individual who will be will have an agreement with a foreign government, and we have identify certain behaviors, for example, providing funding or money, and also communication activities that are aimed at not a specific person or a group, but public, the general public. So we are stressing the individual who has an agreement with a foreign government. On the other hand, we are also trying to provide the commissioner and the officials with the possibility of groups that might not register or in order to make complaints or and also to receive information, providing information on situations where there is not really a person in the registry. And so this will stress, like other measures, on the individual. And what if the person doesn't register? So let's say there's someone who's working secretly, and there could be a complaint or someone who reports them. But if the commissioner is working on the activity, but there is no person registered, so and would that not be a reason to investigate? Thank you very much, Chair. I would say that one aspect of the bill and the work of the Commission would be awareness raising, being awareness of the individual's obligations. For example, let's say that there was somebody who was in a public position who might be approached by an individual, the public official might have some suspicions, so the person will see if they're on the registry, and see the person is not on the registry. And if the commissioner has done their information for their work for providing information, and that is a way that the commissioner could act to identify their not. Is there a registration for the public? There's a public. There is an obligation for individuals, and if we talk about subnational institutions as well, this is a law that is aimed at individuals who might be working for foreign entities. So it's the as I may be wrong, but in the bill, if there is a foreign actor with influence on public policies, they are required to register. But the Winnipeg Laboratory, where there are students or Chinese government agents in the government laboratory, I think this was an act of industrial espionage, and so there was interference in our intellectual property here. Would the registry could have dealt with this kind of a situation, or would it be kind of fall between the cracks? The issue with the registry is transparency for public affairs and foreign agents or foreign actors, and there could be under the law on the security of information. So the registry would not necessarily no. The registry is aimed at increasing transparency or any effort to influence public opinion. Thank you.
Mr. McGregor, 6 minutes, please.
Thank you, Chair. Before I begin with my questions, I need to intervene and address the points that were made by Mr. Cooper. First of all, there are not many public office holders who know intimately the noxious nature of foreign interference than Jagmeet Singh. It has affected him personally. It has affected his family. It has affected where and when he can go in public. So to make those kind of allegations at this committee, frankly, are incredibly disrespectful. And I think the committee should take note of that. The other part I want to make note of, Mr. Chair, is that I had conversations with Mr. Chong yesterday in the House of Commons. I thought they were conversations that were quite respectful. The NDP was quite prepared to program this bill through various committee stages. And just because we didn't go as far as the Conservatives wanted to, they decided to make those kinds of allegations. So I think that kind of misinformation is really unfortunate. It's unbecoming of the seriousness of the topics that we're discussing here. And I think that needs to be cleared up and put on the record. With that, Mr. Chair, I want to turn to a few questions. I guess this is more to CSIS. I mean, having a public registry is one thing, but we as members of this committee can only surmise that there are an incredible number of clandestine operations where a public registry would not affect those actors. They're not going to take the time to register themselves and comply with the provisions of Part 4 of this bill. I know you are limited in what you can say at this public hearing of the committee, but this is a question I posed to the minister yesterday during debate. can you at least talk about, how successful we've been with existing laws in laying charges and getting convictions? Anything that you can help inform this committee as we look at this legislation before us?
As you know, the service, thank you for the question, Chair. As you know, the service is not a law enforcement agency and is not, excuse me, ultimately responsible for the laying of charges or the prosecution thereafter. I can say that the foreign interference space is indeed a very particularly complex one. Much of the activity, as we've discussed in numerous fora recently, is extremely gray. It is not always directly linked back to a hostile actor. There's often several degrees of separation. There can be all sorts of legitimate activity, and a fragment of that could be illegitimate. So the detection, the investigation, and the ultimate downstream prosecution in these cases can be complex. And part of that goes to the package of amendments before you. Part of it goes to the offenses, which I'll let my justice colleagues speak to, and part of it goes to the challenge of using highly sensitive intelligence and disclosing it to the RCMP in such a way that they can use it to launch an independent and parallel investigation, and then protecting that sensitive information when it comes to a court proceeding. And some of the measures we're talking about today will make incremental movements to improve that scenario. So maybe I'll pass it to my justice colleagues who could pick up the back end of that question.
Sure. Thanks, Sarah. I think as my colleagues have said, the idea in C70 is to really build the toolkit for how the government can respond to foreign interference. So the work that public safety has done to establish a registry is one piece, and obviously the proposed offenses that we have in the Security of Information Act are another part of that. So I think some of the activities that we've seen reported in the media, some of that may already be conduct that is criminal activity, but some of it may not. And so one of the things that Bill C70 is trying to do is to sort of bridge that gap a little bit. So in particular, I would point you to the new proposed offense that would be in 20.3 of the SOIA, which is conducting an omission or an offense for a foreign entity. So the underlying conduct there doesn't itself already have to have been a criminal offense. So there's a distinction between two of the offenses we're proposing, and so part of what we seek to do is to make things that are tied to foreign entities, that are a threat to Canada, that harm communities, an offense in a way that it's not currently captured by the law.
Thank you. I also, maybe this is to public safety, in Part 4, under definitions, when you look at the definition of arrangement, it's talking about being in association with a foreign principal, and it can cover just communicating with a public office holder. I know this act is country agnostic, but certainly in the public perception, some countries, there's a hierarchy in terms of the Canadian public's perception of certain countries. I guess there's a concern in the interpretation of the word, like being in association. Can you comment a little bit more on how you interpret that?
So thank you, Chair, for the question. And the definition of arrangement is, as you point out, it's general in the sense that it would not require, and it would be the interpretation of all this would be up to a commissioner, obviously, so I'll preface that by saying that, and eventually to a judge of the federal court if a decision were to be challenged. But an arrangement wouldn't need to be a written contract. It wouldn't necessarily need to be spelled out on paper. It can be a verbal understanding. Ultimately, it would be up to the commissioner, based on the facts available to them, to determine whether there was an understanding, an arrangement, an agreement to conduct these influence activities. And so it's purposely drafted in a way to not limit it to just that one I have a contract that says I will pay you X to do Y.
Thank you. We'll start our second round now. We'll go right now to Mr. Caputo. 5 minutes, please.
Thank you very much, Chair, and I'm very grateful to have the expertise around the table that we have, and I thank all the witnesses for being here. I generally don't put my questions to one person in particular because I know that there's a lot of overlapping expertise here. So please, among you, just feel free to chime in if you feel like you have a good answer to the question. My first line of inquiry looks at what we've colloquially called the Foreign Influence Registry. When it comes to that, what would be the minimum amount of time that it would take to set something like this up, and perhaps even just what would be estimated? I think 1 year was kind of thrown around, but I'd like to get to a bit more of a solid answer, if I could, please.
Thank you, Chair, for that question. A year is what we are estimating currently it would take to set up the registry, and that's taking into account, just to get into some level of detail, regulations that are required to launch the operation of the regime. There are some pieces of regulation that are necessary to do that. There's for example, the information that must be provided to the commissioner by a registrant, and then the information the commissioner shall make available on a registry. So just to give 2 examples, there are others. That requires building an IT solution to do that. It requires developing investigation capabilities. It also requires hiring, the commissioner was referenced earlier, and standing up the physical or organizational structure. And so it is a significant amount of work, and therefore a year is what we are estimating would be required to start the operation of the registry.
So if this bill does not receive royal assent, let's say we are looking at the fall, and the election must occur by a date in October of 2025. Move back a week, I might note, so that the leader of the NDP can get his pension.
Point of order.
McGregor on a point of order.
I've got great respect for Mr. Caputo, but if he wants to have a proper line of questioning without interruptions, he can probably just stay on the topic at hand.
Thank you.
When it comes to the timing of the election, and we do have issues with the timing of the election regardless of what mothers at this table may agree with or not agree with, we're looking at an October 2025 election. If this bill does not receive royal assent before we break, or at least we substantially have done the work, and we are into the fall, we could then be not even in a place to have this in place and functioning prior to the next election if it were to occur in the fall of 2025. Is that accurate?
Well, we're estimating about a year to put in place the registry and the commissioner in the office around it. We can look at how timelines could be accelerated. What I want to mention is that the SOIA new offenses and the amendments would come into force 60 days after royal assent, and that would be well in place for that timeline.
I'm sorry, could you repeat that last part, please?
I said the SOIA amendments and Criminal Code amendments will be in place 60 days after royal assent.
So the amendments will be in place, but I think what concerns people, me anyways, and the people around this table is there's no use in having a registry if what it is aimed to combat really can't be combated because we ran out of runway, which really does speak to Mr. Cooper's earlier points. I mean, we had Bill C-282 by a former colleague of this House, Mr. MP Kenny Chiu at the time, who I think fairly clearly there was electoral interference that may have cost him his seat. And we could be running into that very thing, and that's of concern to me. Now, I'm going to ask a few other questions about the appointment of the Foreign Intelligence and Transparency Commissioner. That the appointment occurs through an order in council, is that correct?
That's right.
Okay. And at this point, there has to be consultation with the House and the Senate. Is that accurate?
That is correct.
Okay. Now, other officials, and I don't want to draw a parallel between the officials, but other such officials, sometimes there has to be a some sort of approval by Parliament and the Senate as opposed to simple consultation, because consultation can be ignored. Would it strengthen the independence of the Foreign Influence and Transparency Commissioner if there was a requirement in the legislation to have formal approval by the House and the Senate?
That's your time, but you witnesses may answer.
Amendments to the bill will be up to Parliament. I think the registry or the legislation proposes a number of elements that would make the commissioner independent in their decisions to pursue action, and those are built into the legislation.
Thank you. We go now to Mr. Biddle, please. 5 minutes.
Thank you so much, Mr. Chair. My first questions will be to CSIS. What operational gaps does this legislation look to fill?
Thank you for the question. Excuse me. Really quite a few. There's 4 aspects of the bill of the current CSIS Act that are significantly impacted by the proposed amendments. Operationally, for the service, one of the biggest activities that we're coming up against limits on is the sharing of information and the equipping of national security partners and stakeholders outside the federal government. Across Canada every day, CSIS officers are engaging with communities, with businesses, with provincial, municipal, territorial governments, and they're encountering significant limits in how they can share information to meaningfully build resilience. And this bill would address that gap with some proposed amendments. And I think the second one I would highlight relates to judicial authorizations. Currently, the service has a single warrant authority that is tailored to highly intrusive techniques and very much appropriately built for that purpose with high safeguards and significant requirements. But today, in the digital world we operate in, a vast number of fairly routine and basic investigative activities. Here I would point to, for example, identifying the individual behind an online disinformation campaign believed to be driven by a foreign state. The subscriber, the identifying information of an account holder online is something we need to go to the federal court for a warrant for. And that warrant requires the same elements that intercepting phone calls does. So you can see that it's not really appropriately tailored to the kind of data that we would be getting. And so one of the proposals today in the bill includes a production order. There are a number of others. There are 2 others in that suite that would allow for much more tactical and regular approaches to the federal court earlier in investigations, and we anticipate that could yield significant operational value and much more nimble investigative posture.
Thank you. In designing the legislation, what lessons, if any, did you take from the enabling legislation that exists in other Five Eyes countries?
For CSIS, we certainly always consider our allies, especially the Five Eyes, in their legislative schemes. Obviously, they're all very different. The UK has done some important work on data that has informed elements of our data authorities. They've just recently amended their data authorities after about a similar amount of time, recognizing the incredibly dynamic pace at which the data and digital world is advancing. We always understand the authorities of our partners when it comes to, for example, engaging with stakeholders and looking at disclosure of information. That question may also want to go to others at the table.
If public safety could...
On the creation of the registry, we've consulted very closely with the US, Australia, and the UK. The UK just introduced the new registry, and we've learned a lot from them. Also, the UK and Australia significantly revamped their national security legislation. in recent years, the UK most recently, and we've taken a close look, and we had good collaboration from them on shaping our legislative package.
Thank you so much. Stick with public safety. Did you consult with Indigenous, provincial, and territorial governments? And if so, what feedback did you receive during the consultation process?
We have engaged with national NIOs and also right holders across Canada. We've received overall very positive feedback. Especially the registry, is a tool that they will be using for the conduct of their activities as governments. And so looking to this tool as a very positive step in the right direction. Some concerns were presented by some of the stakeholders around the application and the respect of the rights of these governments, and obviously the bill has been designed in that context to protect and to these rights and to support their operations as a government.
Thank you so much.
Thank you, Mr. Biddle. On y va maintenant, Monsieur Villemure. Villemure.
Now to Mr. Villemure, 2.5 minutes. Thank you. Thank you very much, Chair. I'm going to ask public safety, my favorite ministry. It's for sure that some of the things are left for regulations, but with regard to the commissioner, and I'd like to know what kind of profile do you imagine for choosing you must have some kind of a profile of some eventual commissioner. What would be that profile? Thank you very much for the question. Finally, the decision of who will be appointed commissioner will be provided for under the advisory committee, and it'll depend on the profile they find, their competencies, will they be qualified for the role of commissioner. There's no profile set out by the regulations, but is a process that I think we're familiar with for selection commissioner. But you said it won't be a plumber or it won't be an electrician. So, without forcing you to give me a response, I'd like to say how broad could this definition be? I mean, there are other commissioners. And I think that this commissioner is a very particular position, and I'm not going to hold you to anything that you say in the future. But what type of person are you looking for? Thank you very much. It's not really up to me to take this decision, but you can look at other commissioners who have similar roles. And that might give you some idea of the type of person would be looking for. But the other commissioners are often judges or ex-judges, and certainly a judge would be an excellent candidate. But this is not the only category of person. There are other types of individuals, and I would like to ask you to maybe broaden the range that you're looking for.
Witnesses may answer quickly.
But 2.5 minutes?
The time is up, but I
Okay.
No, I'm sorry. Maybe I'm confused. I thought you asked a question. No, sorry. I may have zoned out there. I apologize. We go now to we go now to Mr. Mr. McGregor.
Thank you,
2.5
Mr.
minutes.
Chair. Just to public safety, just a very quick technical question on Part 4, the new Section 4, where it's talking about the application of the Act. You mentioned the federal political and governmental processes, provincial and territorial. I was just wondering, like, are municipal and regional governments not mentioned because they're creatures of the province? Like, we can assume they are covered by this. I just want to make sure we're not leaving anything out.
That's correct.
Okay, thank you very much. My next question would be to CSIS, and I know you've already discussed the data set regime. I read the National Security and Intelligence Review Agency's report on the CSIS data set regime, and I think it's safe to say that that report was pretty scathing. There's multiple instances where NSERA is finding that CSIS did not comply with the provisions of the CSIS Act, and it's just littered right throughout their report. Now, I understand, like, you know, we were talking at second reading debate of this bill yesterday about bringing what essentially is an analog law into the digital realm, and I understand that the complexities of data these days warrant an upgrade to the Act. But can you see it from my point of view as a legislator that if CSIS has been unable to comply with an existing statutory framework, why I might have some hesitancy or questions going forward in updating the Act? I guess we're looking for an assurance from CSIS that if we're going to give you these new provisions, that we're not going to see a future NSERA report like this.
Thank you for the question. Certainly, one of the principal objectives of the amendments is to provide a very clear, transparent law when it comes to data sets, to maintain the safeguards that are in place, but also to ensure it can be implemented lawfully and appropriately. And so currently, the complexity of the regime, as you said, and I think I've written that line before, the analog nature of the law when it comes to very complex, messy, unorganized data, it is an extremely challenging space. And so many of the amendments seek to provide clarity, reduce duplication in process, allow for a single, I mentioned already, a single application for a mixed data set, which would take it to the federal court for approval, rather than having to parse data and take two parallel tracks and risk that there's undetected data in one half of that data set, et cetera. So a great deal of the amendments will in fact achieve the objective of ensuring clear and straightforward law that can be carefully adhered to. And absolutely, it is a challenging space. We've seen from our UK partners that they've also dealt with certain challenges in implementing their new law and have already amended it as well. It is novel legislation.
Thank you, Mr. McGregor. We go now to Mr. Jennis. 5 minutes, please.
Thank you, Chair. Winston Churchill apparently once quipped, you can always count on the Americans to do the right thing only after they've tried everything else. And in this case, the Liberal government has definitely tried everything else to avoid action on foreign interference over 9 years. But with C-70, they've finally responded to pressure from the opposition and from the public. Conservatives don't want to let the government get away with sitting on this bill. After 9 years, we've had enough delays. We will push for anti-interference measures to be passed and in place as soon as possible. Now, one important flashpoint for the foreign interference conversation is Hong Kong, because Hong Kong's national security law makes absurd claims of universal jurisdiction, even claiming that if a Canadian in Canada makes statements that are deemed to violate Hong Kong's national security law, they could be charged and even rendered to Hong Kong while traveling in a third country. The manager of Hong Kong's Economic and Trade Office in London has been charged with spying. I've heard concerns from the Canadian Hong Kong community about the activities of the ETO in Canada. Hong Kong is no longer meaningfully separate from the mainland, which raises questions about whether these offices have any legitimacy anyways. So is the government reviewing the activities of the ETO as they relate to foreign interference?
Mr. Chair, this would be a question that would be better addressed by Global Affairs Canada.
Okay, no officials have a response on that? Okay, I would welcome a response in writing if you're able to communicate with your counterparts, because I do think it's relevant to our work today. I have a specific question for CSIS about a personal example and information sharing. As you know, my personal email was targeted as a result of my involvement with the Interparliamentary Alliance on China. The Government of Canada did not have my back. They didn't tell me about this threat or how I could protect myself. I'm a vocal member of the opposition, often critical of the government, and the government didn't report the information to me in a way that would have helped protect myself from foreign interference. The government didn't have my back, but our institutions should have. But unfortunately, CSIS did not have the legal authority to share information directly with me as per the current law. If the changes of this bill had been in place, using my experience as an example, would CSIS have had the authority and been able to simply communicate directly with me right away about these threats and what I could do about them?
I think there's a specific question about the incident itself, and clarity needs to be provided a little bit insofar as the service is not the lead for cybersecurity for the Government of Canada, and I think this issue is relevant to another committee study, so I won't address that specific fact. But on the broader question around information sharing, certainly the service has some significant limitations in the disclosure of information collected in its duties and functions with anyone outside the federal government beyond law enforcement effectively. And so with amendments in the Act, there would be a clear authority to engage outside the federal government for the purpose of building resiliency to threats. And that could be an early, preventative, proactive kind of disclosure of information informed by our investigations. Where information has a personal or private element, the minister would determine that information could be disclosed if it was in the public interest. I don't want to really speculate on a specific scenario such as this one with hindsight, but I do think this would improve our ability to engage.
I understand, but just to drill down, so if there was a threat to me as an opposition member of parliament that you became aware of, it sounds like even after this bill is passed, you would need the minister's determination that telling me was in the public interest before you could tell me. You wouldn't have the discretion to say, Mr. Genis needs this information right away because it's relevant to his life.
I would correct that presumption. In fact, the service, if there were a manifest threat occurring under its threat reduction mandate today, it could disclose information for the purpose of reducing a threat when the threat is unfolding, active. The amendments in the bill do something different. They enable an earlier and broader engagement for the purpose of building resiliency to threats before the threat
with
is
ministerial
real.
consent, though, or not?
No. No ministerial consent required.
Okay.
But no disclosure of personal information.
Okay. That seems like a gap to me, but I'll go on to one more thing here. Just following my general skepticism about the government's will to address this, why the requirement of Attorney General consent, and what would happen in the case where the Attorney General might be in a conflict of interest, such as where the Attorney General might have personally benefited from foreign interference in his or her own riding?
Thank you for the question. The requirement of Attorney General consent already exists in the SOIA, and so the new offenses which would be integrated into the SOIA would, that requirement would continue to apply. In general, the requirement of Attorney General consent applies to ensure that there is the proper assessment of the key elements of whether there's a reasonable prospect of conviction and the public interest in proceeding with a prosecution, that assessment is taken at an appropriate level given the context of the interests at stake. And in practice, in our system, that Attorney General consent is usually exercised by the Director of Public Prosecutions.
Thank you, Mr. Genis. We go now to Mr. McDonald. Mr. McDonald, please.
Thank you, Chair. Thank you, the witness, for being here today. I just want to follow up on possibly the regulatory framework from each of your departments. Can you provide any examples of the regulatory framework that you're dealing with?
Maybe, is your question, Chair, directed at the regulatory framework that would apply to the Foreign Influence Transparency Registry? So the regulatory framework that will underpin that will need to be developed, but to give you, to respond to the question, Chair, for example, there are parts of this that need to be further identified. For example, administrative monitoring penalties is a tool that will be available for a commissioner in terms of imposing an amount of penalty if...
Point of order, Chair. I can't hear.
I apologize.
Could you
Please,
could you start
please
again,
repeat
please,
your answer,
if you
if
don't
you
mind?
Absolutely. I think we've spoken, Chair, about a few things in the legislation for the Foreign Influence Transparency Registry that would require the bringing into force of regulation. For example, individuals who are required to register will have to supply the commissioner with certain type of information that will be designated by regulation, and could include things like very obviously name, address, and things like that, but also the nature of the agreement and who the agreement is with. It would also establish via regulation what kind of information the commissioner would be obligated to publish online in a registry to basically render effective the transparency. It would also determine the amount of monetary penalties a commissioner can impose once they have issued a notice of violation. So those are some of the key examples of things that would be brought in via the regulatory framework. It would also specify the kind of parameters for sharing information with other agencies. It could also, you will have noticed, there are very few exemptions in the bill that would apply if adopted. The regulations do allow the Governor and Council to bring in more exemptions, although the bill is designed in a way that there are very few exemptions because the bill wanted to create the maximum or the minimum amount of gaps or ways of escaping registration. And so some of those examples are what would be required in terms of regulatory framework to implement the legislation.
Thank you, Mr. Bilodeau. And I'm going to ask change direction a little bit, but can someone describe some of the defense mechanisms for the people at home, just to briefly describe the defense mechanisms that could be used? And I also want to state that CSIS has been around a long time and has been doing great work. Obviously, when we had over 5 million cyber attacks from September to December in 2023, I think it's really important to identify the work that you've presently done. Obviously, technology is changing in the digital world, so it's changing very quickly. So I want to identify something else too, that someone said that it's in the bill, I believe, 5 years review. Is that correct? Is that too long?
Thank you for the question, Chair. The 5-year review is proposed there. It's consistent with what exists in legislation, and we mentioning earlier how in viewing what other partners are doing around the world, and Five Eyes particularly. So that's a proposal there. It wouldn't, of course, preclude the Parliament's ability to study or to bring legislation beforehand. What it does do, though, we think, and why it's proposed, is that it allows for the government to propose legislation on a clock and to have a review of to ensure that CSIS's authorities are fit for purpose, whether its authorities remain justified, and provide a regular review outside, hopefully, of emergency situations. And it also allows for civil society and stakeholders to galvanize as well to prepare themselves to contribute to that debate and that discussion in hopes of maturing a national security conversation in the country.
Now, half a minute.
And quickly, I don't have much time, but I did mention defense mechanisms, and perhaps I won't get to all of it, but is there anything in particular that stands out from CSIS that maybe the general public should be aware of when they're reading the stuff in the media and the misinformation that sometimes has been directed from other sources?
I think the provision that would stand out the most, or that would be the most of interest to Canadians generally, is the information sharing provisions and the amendments in the Act with respect to that. The ability of CSIS to share information outside of the federal government is something that we think a lot of Canadians, especially those in important sectors of the economy, for example, in the academic sector and in communities as well, who are victims of disinformation campaigns, misinformation campaigns, we think that'll help build that resilience and help protect Canada's democratic health as well.
Thank you, Mr. MacDonald. So that brings round 2 of questions to a close. The following round will be the same pattern as the one we just had, but I'm suggesting we take a short break. Is the committee in favor of a 5-minute, 10-minute break? I'm sorry? Keep going? Okay. We go now to Mr. Shipley for 5 minutes.
Thank you, Chair. And my first question, I'm going to build off of what a couple of my colleagues, Mr. Cooper and Mr. Caputo, were speaking about, and more really of time is of the essence with this bill. We are aware of the last few elections or more, there's been foreign interference situations with different electoral districts across Canada. So we know there's a looming election. We heard the date this morning, October 2025. That's not that far away. We've also then heard that it's going to take approximately a year to really implement and get this registry set up. My pre-political life, I was in the private business world, and in a year, you could incorporate a company, find a facility, bring in inventory, hire employees, get customers, ship, and start making profits in a lot shorter time than a year. Could maybe someone from each department please enlighten me how this implementing could possibly take close to a year or more?
Thank you, Chair, for...
Just for context, so the amendments to SOIA will be in force 60 days after royal assent and CSIS. So that doesn't require the timeline. If we're creating a new regime, which is the commissioner, then there's some delay. So I just want to have a broader perspective on the bill. But no.
Thank you for that, Sebastien. The year estimate is based on the number of regulations that need to be brought forward and promulgated by the Governor and Council. It also requires actually setting up an office. While the proposal in the bill is to establish it within a department, it does require staffing up an office, for example, hiring a commissioner. We are going to be dealing with Canadians' private data in establishing the registry. That requires a privacy impact assessment to make sure that we're dealing with that data in a way that is appropriate and consistent with privacy laws. It also requires establishing an IT platform to receive information for the registry and then publish that information back out to the Canadian public so that they can consult the database. It will require developing guidance for Canadians in terms of expectations. For example, if we look over at our friends in the UK, the law came into or received royal assent last summer, 2023. They issued guidance in February of this year that is intended to educate people on their obligations with regard to the registry. The goal of the registry is to increase transparency, and one of the key ways of doing that is by clearly communicating to Canadians who might be in arrangements with foreign states. And because it is country agnostic, that encompasses every foreign state. What are their obligations in terms of registering? And so there's a significant part of this that is educating the Canadian public on their obligations. And building guidance in will make sure that people know what their obligations are. And so those are some of the steps that will need to be put in place so that we have a proper functioning registry when it gets launched.
Thank you for that. Is there anything specific this committee could do here today or in our meetings coming up that we could help anybody assist to speed this up at all? Is there anything specific we could do?
I think we're at your disposal. We will be here to support the work of the committee and answer your questions, and we'll stand ready at any point in time to support that work.
Okay, thank you for that, and hopefully it goes as quickly as possible. Speaking of the registry, there's been some concern that some foreign governments may be able to exploit diaspora communities by enlisting volunteers rather than paid agents, which may bypass the need to register on the foreign agent registry. Has that been thought of at all? Is that factual?
Yeah, so the registry does not require the payment. Their legislation, the bill, does not require the payment of monies for an arrangement to be captured by the registration obligation. It can be an understanding of doing a favor or anything like that. It does not require payment.
Thank you. And has a charter statement been completed on this legislation?
Thank you, Chair, for your question. So, as is the normal practice, the Minister of Justice will be tabling a charter statement that will outline the potential implications of rights and freedoms protected under the charter by Bill C-70. I don't believe it's been tabled yet, but as per the practice, that would be our expectation.
Thank you.
Thank you, Mr. Shipley. We go now to Mr. Gahir. Mr. Gahir, go ahead with 5 minutes, please.
Great. Thank you, Chair, and thank you to the officials for appearing before the committee. So my question is sort of for all the witnesses and whoever thinks that they're best to answer should answer this question. But we know that under the proposed framework, individuals or entities who enter into an arrangement with a foreign principal and undertake activities to influence a government or political process in Canada would be required to publicly register. Could the witnesses talk about the penalties that would be imposed or the consequences that could be imposed if that entity or individual does not register?
Thank you, Chair, for that question. The legislation proposes a compliance or some number of compliance regimes, but I think I'd like to start the answer by maybe giving an example, and might be the best way of appreciating how the bill proposes this to work. Somebody may, for example, forget to register their activity. Good faith error. The commissioner would have an ability to, if they so desire, issue a notice and say, "Sir, Madam, company, you should have registered under the Foreign Influence Transparency Registry." That person brings themselves, says, "You know what, I should have," brings themselves into compliance by registering. There will be instances, I'm sure, where somebody will deliberately not register or obfuscate. The commissioner at that point will have a decision to make following an investigation whether or not to deal with that breach or that contravention, either from a civil perspective or a criminal perspective. And if the commissioner decides that the best course of action is to issue a notice of violation, in addition to issuing that notice of violation, could impose administrative monitoring penalties, the amount of which will be determined by regulation. The commissioner would then also be obligated to publish that notice of violation so that Canadians are made aware that an individual or a company failed in their obligations to register. Of course, at that point, there's also the ability of an individual found to be in violation to refer to the federal court for judicial review. That's part of the is proposed in the bill. Finally, there are criminal sanctions that could be imposed if the commissioner believes that the breach is so severe that it warrants criminal investigation. The commissioner could then refer the matter to a police of jurisdiction, the RCMP, for example, where the police service, the law enforcement agencies would investigate and then work with prosecutors, but that would be done independently by the police at that point. So that gives you a bit of an idea of the scope. Obviously, one big part of that is education up front. We're hoping to make sure that people comply as much as possible.
Great. Thank you for that comprehensive answer. I think I want to take this, I'll posit my own hypothetical. Let's say that there is an individual, that individual is a foreign agent, and there is a conviction that sort of will come from that, that will lead to criminal or potential conviction that could arise, that could lead to jail time. What level of arrangement is required between that person, that individual in Canada, and that foreign principal that is overseas? And knowing that there's probably layers of separation that is between them, what level of arrangement is required? Is it implicit? Does it have to be explicit? What is that bar?
It's a very good question, and Chair, I'll leave issues of beyond a reasonable doubt and things like that aside. But establishing whether an arrangement exists between an individual and a foreign state will be a matter of the facts of the situation. The commissioner will have tools, investigative tools, the ability to compel information to try and determine the relationship between an individual and a foreign state. It is not always easy. I think you are correct in making that statement. But there will be tools. There will be the ability to work with intelligence services and law enforcement to get information to try and make that determination. But at the end of the day, it will be a collection of facts to determine whether or not there is an arrangement. And as I said earlier, it does not need to specifically be a written contract, although obviously that makes it a lot easier. But it can be a totality of circumstances, factual circumstances that can lead to a conclusion that there was an arrangement, and ultimately would be up to a court to decide whether or not that burden's been met.
Great. Sure. Just how much time do I have left?
35 seconds.
35 seconds. So I guess I just want to end with a statement saying that this does worry me that foreign agents could operate through a chain of command, and it's very hard to trace that chain of command back to the individuals that are overseas and acting as a foreign principal. So I think there should be emphasis placed on the actual conviction, because if you can't get a criminal conviction for an individual that is engaging in these acts, then what's the deterrence? Deterrence is basically just the legal expenses to deal with the embarrassment from and the inconvenience from a trial. They're not going to actually get convicted if that chain of command can't be traced back. Thank you, Chair.
Thank you. If anyone wishes to respond, they may.
No, we take note of the concern, and I would say that the element of all this that is key to Foreign Influence Transparency Registry is bringing transparency, and even bringing sunlight to associations is a key valuable tool, and I know that the service agrees with that as well.
Thank you.
Monsieur Villemure.
Mr. Villemure. 2.5 minutes. Thank you very much, Chair. 2.5 minutes, very fast. Concerning the... you can't escape, sorry. With regard to the Commissioner on Interference, I would like to know why they would be with the Public Safety Ministry. They say there are a lot of measures in place already, but I'm concerned because we're talking about overlap, and would the Commissioner be completely independent? And but independent, it depends on the individual. And I'd like to come back to this post, and I'm not assuming there would be any interference from the ministry or the minister, but how can we ensure that the Commissioner would be independent and in the selection of the Commissioner as well? And what procedures or guarantees are there? Thank you very much for the question. And as I said, that it will be a decision by Parliament to adopt the law, and there could be amendments, but the bill provides for independence for the Commissioner to take decisions with regard to the implementation of the law and what inquires to continue or to not continue, and all of this work, all these decisions will be done independently. Sorry, but there's independence in the actions, but there's no independence for the ability. But the independence, the Commissioner must make a report every year to the Minister, and that will be provided to Parliament every year. So the Commissioner is responsible to the Minister and to the Parliament. But why not include political parties in the bill? The bill includes the consultations for but in the for example, financing of public parties by foreign actors. I think that if I've understood the question correctly, the political process defined in the law includes, for example, if there were interference or by foreign actors, this would be something that would require there be a registration with the Commissioner. Thank you very much for reassuring me.
Merci, monsieur. Mr. McGregor, please go ahead, 2.5 minutes.
Thank you, Mr. Chair. At risk of repetition, I want to delve again into the definition of arrangement. So let's just, for argument's sake, say that I'm an ordinary private citizen, and by virtue of my last name, I have an association with the Scottish government. And I communicate with a public office holder about a proceeding in a legislative body. I'm just trying to see what's my level of association that would trigger me having to register.
Thank you very much, Chair, for that question, and it's a good question to make I think what is an important point. This legislation isn't about regulating what people can say or not say in advocating for positions. So I think that I want to make sure that that is completely clear. Where it imposes a degree of transparency is where that advocacy is being made on behalf of a foreign state or in association with a foreign state. And so the best answer to that is if you are a private citizen, Mr. McGregor, and you're looking to, you want to meet with a deputy minister because you think that exposition by your government is, would be helpful, and you're not doing it on behalf of a foreign state, but you're doing it out of love for your country, for example, that doesn't require registration. But where you have an understanding with the foreign state that you're doing that for them or in association with them, that is what triggers the requirement to register.
Thank you. And then going on to the section 27 where it talks about regulations, can you walk me through those in terms of like the different classes? Is there obviously going to be sort of a listed difference between someone who has an association versus someone who's acting overtly under the direction of a foreign entity?
Thank you again for that question. And Section 27 sets out the regulations. 27A adds potential classes of individuals that would fit the definition of public office holder. It's meant to identify classes. It's not meant to identify countries or organizations. It's meant to make sure that there's enough flexibility in the legislation through regulation that if we believe that a certain group of people should be captured by the registration obligation, that there's an ability in the regulations to do that. The definition of public office holder is well known. It's established in the Lobbying Act. It is fairly broad. But if we were come to realize that it would need to capture other classes, this would be the way to do it.
Thank you, Mr. McGregor. We go now to Mr. Cooper. Mr. Cooper, 5 minutes, please.
Thank you very much, Mr. Chair. To the public safety officials, the coming into force of the Foreign Influence Registry is subject to an issuance of an order in council by the Cabinet, correct?
That's right.
That's right.
And there is no date prescribed for when that order in council would be issued, is there?
That's correct.
So there is no date, correct? Okay. And so it would be correct to say that there's nothing in the legislation that would prevent the government from differing in issuing that order in council.
It is up to the governor and council to decide when that is.
Now, with respect to, so yes, and the answer is yes, there's nothing to prevent the government from differing.
Yes, it's up to them to decide when.
Okay, thank you. And there's much that has been left to regulation, including with respect to administrative penalties, as well as the contents of what must be disclosed to the commissioner. So once the bill passes, assuming that it does, I think it will, is there going to be another lengthy consultation process for what should be included in the regulations? We have seen that with respect to other bills that have been introduced and passed that have been delayed in terms of implementation because of another extensive consultation process. So is that in the works?
Thank you for, well, I don't know if you want to answer
No, I
first.
just want to say that I sort of disagree with your premise. I think this bill, FIDA, doesn't leave a whole lot left to regulations. A lot is in the statutes. And so the regulatory framework will be quite contained if you look at comparative other pieces of legislation. But in terms of the process, Richard.
Thank you. And some of them are simpler than others, determining the amount of penalties that corporations or might have to pay in terms of an administrative monetary penalty or individuals. Sometimes there's a different initiation in regime, so that's fairly straightforward. But to answer your question about consultation, some of them might require consultation more than others. Some of them are very technical, but that is something, for example, if we were to consider adding classes of exemptions or another exemption to the regime, you can imagine that would require consultation.
I anticipate that there would be some sort of consultation process that could potentially take some time because certain aspects of it may be more complex than others.
It is possible that there will be some consultation activities on some
Okay, so I think this just underscores that we have more delay and underscores why time is of the essence, and it just underscores that this should never have been here, and the reason we are here is because this government failed to act, failed to move forward with establishing a foreign influence registry a year after the consultation process has ended, and only now are we beginning to study a bill that is, as of yesterday, the first day of debate at second reading stage. Moving on to the foreign influence registry provisions, specifically the definition of public office holders, I would note that, for instance, appointees of the federal cabinet constitute a public office holder, but provincial cabinet appointees of provincial cabinets are not included. Similarly, officers, directors, and employees of federal boards, commissions, and tribunals constitute a public office holder, but the same would not seem to apply with respect to directors or employees of provincial or municipal government corporations or agencies. So why were those left out?
So thank you, Chair, for the question. I would point out that the legislation provides that it would apply to provincial territorial governments when that is brought into force. Same thing with Indigenous governments. They would apply to them when that is brought into force.
I understand that, but and it applies to federal government as well. But I cited two specific sections in terms of what constitute public office holders. There appears to be a gap there. I want clarity as to whether I'm correct in that interpretation, and if I am, why were those left out?
I'd have to go back and look at the language of the provisions. I would say that the legislation allows, through the regulation, of adding classes of people. And if we became aware that there were a class of people that needed to be captured, it can be done.
Well, very simply, appointees of the federal cabinet, but not appointees of provincial government.
Thank you, Mr. Cooper.
So that would be part of the conversation. The reason we brought into force, or separately, the provincial and territorial components was to ensure collaboration with our provincial and territorial colleagues, so we could do that in an orderly way, considering that, and that can be part of those conversations. And I'm not saying it won't be. I'm just saying it's right now.
More delay.
Thank you, Mr. Cooper. That's enough. We go now to Mr. Arya. 5 minutes, please.
Thank you, Mr. Chair. My question is generally to all three witnesses, all three departments. Have you guys, I know that you mentioned that the foreign interference laws passed by our allies, the Five Eyes, including Australia, has been looked into. Are you guys aware of the first case in Australia that was tried, which was reported by New York Times on March 16th this year? You can start with CSIS. You are aware of that article. And I'll just mention what New York Times said. It's not me, but what it said was the first case tried under Australia's foreign interference laws has raised tough questions about the breadth of the regulations. I'll just quote some sentences from the article, and I would like to know from you guys if that is what can happen here in Canada under this new law. The fundamental thing about that case is the police officers asked the man what he meant when he said that involving an Australian government minister in a charity event could benefit us Chinese within the courts. Was he talking about mainland China and the Chinese Communist Party, or the local Australian Chinese community? Depending on the answer, depending on the judge, jury, or the government officials, whether when he says us Chinese means Chinese government, or us Chinese means us Chinese diaspora. Depending on the answer, yes or no, he could face 10 years in prison. This event is about $225,000 donation to a community hospital, which, according to prosecutors, would at some point have become the basis for a pro-China pitch to a local member of parliament. So my question is, are we do you think it is possible that this case can happen in Canada under this proposed law?
Thank you for the question, Chair. One of the discussions around this, of course, is the very gray nature of foreign interference and making those connections. What is included in this bill is a package of measures that together seek to provide transparency around foreign interference activity, help us.
Maybe I can ask the Department of Justice.
I don't have the details of the case specifically, but what I can say, if there's an arrangement that's being made within a foreign principal and someone in Canada to make that advocacy, that
please
would be...
look up the case and get back to the committee with an answer.
Sure, absolutely.
Okay.
Yep.
Then the Department of Public Safety and Emergency Preparedness.
Thank you for the question. I'm speaking on behalf of the Department of Justice, but I can address the question. Certainly, we have benefited from having seen the experiences of the Australian legislation, and the bill reflects efforts to learn from the experiences of Australia. In particular, some of the definitions in the Australian legislation have been criticized as being vague and not providing sufficient detail to guide law enforcement and prosecutors. We took note of that in the design of the current legislation.
Again, I'm quoting from the article. It has become a cautionary tale for the country's large diaspora communities. In theory, the new laws were an effort to defend democracy against foreign influence. In practice, they have raised tough questions about when such intentions might drift into xenophobia. So how are we give assurance to the diaspora communities in Canada that this will not happen here in Canada? We'll start with CSIS again.
I can start by saying maybe that the consultations that preceded the introduction of the legislation were extensive and included discussions with a wide range of diaspora communities, community leadership, including, for example, the Cross-Cultural Roundtable on security. So we've heard these concerns, and they've been expressed loud and clear during the consultation phase of the bill, and that input that was provided by these communities and by our partners and stakeholders have been incorporated into the drafting of the legislation in a way that we expect will prevent the kinds of issues that you're raising this morning.
Okay, thank you, Mr. Arya. So that wraps the third round. We'll start a fourth round following the same pattern, except at this time, I think we'll run out of time by the time we finish with Mr. McGregor. So we'll end it there. So and also, before we rise, I want to encourage all parties to get witness lists to the clerk, hopefully by noon tomorrow in some priority fashion, so that we have a sporting chance of setting up meetings for next week. The clerk will do his best to organize things in terms of who is available and when they can get there, and in terms of the priorities that we provide to him. Having said that, I will now go to Mr. Caputo for 5 minutes, please.
Thank you, Chair. And Mr. Biddle pointed out that I was incorrect during my last round, so I should correct the record that the NDP leader's pension will vest prior to that date. It was 25% of his caucus that I should have been referring to. Now, in any event, when we're talking about sabotage and the sabotage-related offenses, we are speaking about infrastructure and critical infrastructure. So the question I have is this. I'm going to see if I can find the exact wording of the provision where it talks about essential infrastructure and the definition of that essential infrastructure. My question is whether we're talking about, for instance, under section 52.1 sub 2, transportation infrastructure, information and communication technology infrastructure, et cetera. We have, it looks like 8 or 9 enumerated grounds. 8 enumerated grounds, and then the regulations can add other infrastructure. So would the offense of sabotage apply only to infrastructure that has actually completed, as in other words, like an existing rail line or existing telecommunications line? Or what about when a private company or the government is in the process of planning or constructing that infrastructure? Would the offense of sabotage apply to that as well?
Thanks for your question. What I would draw your attention to is the definition of essential infrastructure in the bill. And what it says is that it means a facility or system, whether public or private, that provides or distributes services that are essential. So I think it would be a question of the specific facts and the operational state of that infrastructure. In theory, something that is still under construction is not actually at that point providing or distributing what we've defined as essential infrastructure here. Obviously, interference with that type of thing may be covered under other offenses in the code, but may not necessarily fall within the offense of sabotage related to essential infrastructure as in the bill.
Okay, that's interesting. I mean, to me, that's a bit of a gap because foreign interference could certainly seek to undermine that which is being built in Canada for infrastructure. So that might be an area that that should be considered for amendment. One of the questions I have is in relation to the offense of sabotage as well. The offense has a 5-year maximum, and this to me feels like a fairly serious offense. Is there a reason why this isn't a higher maximum for sentence?
Just to correct, it's a maximum 10-year sentence for sabotage when committed by way of indictment.
Oh, okay. I'm sorry. I thought it went from 2 years to 5 years, but I must have misread that. I apologize. Yeah. Okay, thank you. I believe Mr. Genis is really chomping at the bit here to get in a last couple of questions, so I'll cede my time to him.
Always. Thank you, Mr. Caputo. One gap in terms of the response here has been around people facing coordinated discrimination based on political activity, people in diaspora communities who are involved in pro-democracy activity, for example, who then face various forms of discrimination that may be officially or unofficially coordinated from abroad. One instance I heard of recently, for instance, was someone involved in pro-democracy activism in terms of Hong Kong who faced negative consequences from their landlord as a result of it. Now, I have a private member's bill, C-257, that would add political belief and activity as prohibited grounds of discrimination, which I think is one solution. That wouldn't apply in provincial jurisdiction, but it would apply in federal jurisdiction. You could imagine similar models being adopted provincially. But I think this is one problem that Bill C-70 does not solve. I'd be curious for your feedback, especially the justice officials' feedback on this, and what steps could be taken to protect people from discrimination that may be coordinated from abroad and may respond to political activities that they're involved in here in Canada.
Thanks for the question, Chair. I'll save your remarks, and if my colleague has more to supplement, he can. I will admit I'm not familiar with your private member's bill, but I'm going to guess based on how you've described it that what you're talking about is adding political belief to the Canadian Human Rights Act. Is that correct?
Exactly.
Okay. So the Canadian Human Rights Act is a little bit different in the sense that it applies as between relationships between private individuals and discrimination that may take place there. So the stuff that we have in the bill would not cover those scenarios unless there is a link to a foreign entity, if that makes sense.
Okay, so if there was a link to a foreign entity, would it be covered if a foreign entity was, if the person who was doing the discriminating was involved or connected to a foreign entity in some ways, but that was in a private relationship? Would the bill impact that, and how?
That's your time. Witness may answer.
So maybe just to clarify terms, so discrimination normally is how you provide goods and services in the sense of the Canadian Human Rights Act, right? So I think my colleague can supplement, but I think what could potentially apply here is, for example, if you are doing something as the landlord at the direction, benefit, in association with the foreign entity, that could potentially be covered by the new general foreign interference offense.
Thank you.
Thank you. Just briefly, if the form of the discrimination rises to intimidation, threats, violence, or coercive behavior that doesn't give the victim a choice in the matter, then certainly the new and newly amended offenses in Section 20, 20.1, 20.2 could apply to those circumstances.
Thank you.
Thank you. We go now to Mr. Gahir. 5 minutes, please.
Great. Thank you, Chair. So I understand the sensitivities around asking this question, but could the officials please speak to the intelligence gathering mechanism to establish that there is an arrangement between a foreign principal and an individual or entity here in Canada? What's involved in that intelligence gathering?
Thank you for that question. I can start off, and I won't speak to the collection capabilities of intelligence partners, but I will speak from a perspective of a client or a consumer of intelligence. We get intelligence shared with us, and that can be informative. Again, it depends on the nature of the intelligence in terms of its corroboration, its value, how it can be relied upon, caveats associated in terms of its use. And so there's a structure around intelligence, how it's shared with law enforcement. I am not an expert in that field. I would defer to my colleagues from the service or from the Department of Justice on that, but to maybe clarify or take it away. The commissioner does have investigative powers to collect information, but it could also receive intelligence that has been collected by partners. And so there's a distinction there, and obviously when you get intelligence, there are limits to how it can be used that are imposed by the process.
Okay. So is there a mechanism to ensure that there is information sharing between different government agencies? So like, what if different agencies have different pieces of the pie? What mechanism is there to ensure that they sort of combine that together to see the entire picture? Maybe that reaches that bar where they can launch an investigation.
So the service, for example, is unlimited in the disclosure of information and intelligence to the Government of Canada. That's its principal principal client, and of course it can disclose intelligence widely. Are there processes in place for ensuring sharing is wide? And yes. And are they perfect? No. This is an area that has come up in the recent public inquiry report, and I think we have a significant commitment to address some of the issues in this respect. When it comes to sharing with a particular body, it's slightly different from more routine intelligence gathering and sharing. We will, I assume, I'm guessing, have to have some mechanisms, an MOU, a process, a structure for doing this. It's not until the bill becomes law. That's not the current focus. But the broader integration of the security and intelligence partnership and key clients is very, very strong at all levels. And the sharing of intelligence is a huge priority. There is some process improvements that can be made.
What I can say is that, essentially the service has the legal authority to share. The legislation for FIDA sets out that the commissioner can receive the information and consume it and use it. There will need to be arrangements, the MOUs that established between the two organizations for receiving the information, and also make sure that the classified systems are in place to receive and store the information. That's one of the reasons why the commissioner would be housed in a department to make sure that we optimize the use of the information sharing arrangements and the infrastructure that is there for the intelligence to be shared with the commissioner.
Great, thank you.
Mr. Gahir, you have 1 minute left, if you wish.
Oh, I have 1 minute. Okay. So another question that I wanted to ask is, who are the entities that the officials believe or the government believes are most likely to register under this new act? Is there sort of a preconception of who's likely to register?
It's a good question. We would expect, Chair, anybody who has an arrangement to register. Obviously, there are people who, by the nature of their business, work with foreign governments legitimately that would want to or will be required to register. And so if you are in the business of advocating on behalf of clients and you're doing that on behalf of a foreign state, you will have to register with if the bill is passed, with the Foreign Influence Transparency office. And therefore, we expect, obviously, that group of people that is well versed in registering for the Lobbying Act to also be required to register when they're in an arrangement with a foreign principal. That would be one example.
Okay, if I can just quickly get in one question. If they have registered, and what's the bar for those individuals and their activities being monitored to see if they're actually, they've registered, but are they now abiding by the laws that this country has, or are they skirting that even though they have registered?
I think it's a good question, Chair. The legislation does have provisions requiring updating of information to the Commissioner on their activities. That will be detailed in regulation.
Thank you, Mr. Gahir. C'est maintenant Monsieur
Now, Mr. Villemure. Thank you. 2.5 minutes. Thank you very much. Another question for public safety. When we read Part 1 of the law on CSIS, it means that they have to be able to get information from universities to receive Canadian funds. I'm not sure that all universities would be required to register. And are those universities some of the bodies that would be required to register? Thank you very much for the question. To take an example, if a university has an agreement with a foreign government for the activities under the laws and representing or communication or funding with a view to influencing a government official or a policy, the entity would have to register. But everything will depend on the type of relationship and the activities and the context for the university. So it's really, I think there would have to be all three criteria to be met, and whether it's a university, a public institution, or a private business. No, but but the foreign entity, but the person who is influencing or who is someone who is in a university who is acting on the part of a foreign entity, the commissioner will publish this information, and there will be some transparency required with regard to the role of the foreign entity. But if this relationship will lead to a change in policy, would the foreign entity have to register? Well, it depends on how the influence transpired. If it was someone who is hired to implement this influence, but there could be some other provisions or situations that might be applicable beyond the registry. Can you explain this a little bit more? But the law is fairly clear on the obligation to register and who is obliged to register. I think it's Article 3. There are criteria, and the commissioner, this is something that the commissioner can also seek to clarify, and the commissioner is responsible for applying the law and for entities meeting their obligations under the law and for their registration. And this is something that's in the law. Thank you.
Mr. McGregor for 2.5 minutes.
Thank you, Mr. Chair. I think this question will probably be to the Department of Justice, and I'm just flipping through the different sections of this bill, and the theme of my question is on legislative harmony and consistency. I want to draw your attention to the amendments to the SOIA, specifically on page 32 when it's talking about the application of the Act. There it makes specific mention of municipal, political, or governmental processes, but in Part 4 that is excluded. Likewise, if you look on page 31 of the SOIA, the definition of public office holder is quite thorough and very defined, whereas in Part 4, the definition of public office holder is not as thorough. And so I'm just wondering, from the Department of Justice's point of view, if we're looking at possible amendments to this act, what is the preference in terms of making sure that these two acts are in harmony? Would you like us to be as specific as what's included in the SOIA when we amend Part 4? I'd just like to have some guidance on that, please.
Thank you for that question. The definitions that are used in SOIA are with the context of SOIA and the offense itself in mind. And we're clearly inspired, as you note, from other provisions and other categories of public office holders. So the offense of interference with political or with political processes or governance involves a category of public office holder which I agree is quite extensive and in fact is open-ended to a certain extent as it's defined. That works well within the context of SOIA and within the context of that particular provision. The other categories of public office holder are designed to work well with the other regime. So that's what I would say. Yes, there are similarities, and yes, there are differences, but those are intentional.
Thank you, Mr. McGregor. So that brings our questioning to a close. I'd like to thank our witnesses for being so enormously helpful and for showing up on such short notice. It's really appreciated. I also would like, Mr. Villemure would like a few words with the committee, but before that I want to make sure to remind everyone that we need witness lists. Each party should submit their witness lists to the clerk in a prioritized manner. In order to schedule for Monday, he'll need them by, those witnesses by noon. Mr. McGregor, you had a question?
Yeah, Chair. Just given how heavy our workload is going to be next week, and given the timelines we're dealing with Bill S210, I'm just wondering if we have unanimous consent from this committee to ask for a formal extension so that we can give S210 proper study. Because C70 obviously is going to take priority at this committee. Can I get unanimous consent for that?
I've already had, there's no unanimous consent, so thank you.
Thank you.
So Mr. Villemure, please go ahead for a few minutes.
Merci, Monsieur le Président. Thank you very much, Chair. I'd also like to, given the our work, I would like to ask a unanimous consent whether when there is a panel for 2 hours, we could start back the time for questioning when there's only one panel present for the entire meeting.
We'll lose time. We'll lose time on it.
I should point out that what we've done today is fairly unusual for us. We were kind of rushed, and that the routine motions that we are operating under kind of proceed in this manner. I'm not sure if there is willingness to adopt that on unanimous consent at this point. If you could bring it back next time, maybe that's
yeah.
What
Let's have some discussion among ourselves.
All right. Thank you for your suggestion, and thank you once again to the witnesses. With that, we are adjourned, and thank you all.